and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law, and well, hey, anything else we want to talk about. Now, on this episode of the Red Wagon Estate Planning and Elder Law Show, we are going to talk about probate in Pennsylvania. So this will fall squarely under the estate planning and elder law category. We have been getting a lot of questions about probate. What has to be done? What does it look like? What are the requirements? Do I have any liability as the executor? So this podcast is going to be all things post-death administration, specifically in regards to probate administration. So before we dive into this, just a good reminder of our disclaimer. Please do not take what you hear from this show, or any other show for that matter, to constitute legal advice. If you are looking for legal advice, please contact an attorney licensed in the state that you reside in, who practices law in the area that you are looking for advice in. And then, and only then, after you meet with them and discuss the specific facts of your circumstance, should you constitute that to be legal advice. This show, and any other show for that matter, should be looked at for informational, educational, and entertainment purposes only. At Belomo & Associates, we educate so that what happened to my family doesn't happen to yours. We offer free educational workshops in our office on a regular basis in the areas of pre-planning or estate planning, crisis Medicaid planning, long life care planning, special needs planning, and post-death administration. Now, this podcast is going to fall squarely under post-death administration, but specifically probate administration. So there are two types of post-death administration. It could be probate administration or trust administration. This one, because it's much more common, we're going to discuss probate administration in the state of Pennsylvania. Now, if you've been listening to our podcasts, we have talked a lot about different advantages of trusts, why sometimes trust makes sense, and why in a lot of cases people do want to avoid probate. But the truth is, not everybody does. Not everybody wants to spend a little extra money on the front end. Not everybody cares about asset protection on the back end. And in some cases, they simply want to just get it done simply, quickly, and easily, and they aren't concerned about the other items that come with it that we discussed on the other podcasts. So what we've been hearing recently is, okay, I understand that there are advantages to avoiding it, but the truth is a lot of people still have to go through it. And so can you do a podcast on what does that look like? What should we be looking out for? What does it mean? So let's take a step back and define terms. If you have assets in your name alone at the time of your death, meaning they're not jointly owned, there's not a beneficiary designation on them, straight up in your name alone with no beneficiary, no joint ownership, that goes through your will. Your will goes through probate. Probate is the legal process by which we carry out your wishes after you pass away for assets that are in your name alone. Probate is not good nor bad. It is literally the process. It doesn't have a positive or negative connotation. It's just the state's rulebook for cases when you have assets in your name alone, right? Now, the first thing is we look in the will to determine who is the executor if he's male, executrix if she's female, who is going to step in the shoes of the decedent at the time of death. So it's important to remember that when a person passes away, powers of attorney are no longer valid. So when you're talking about making decisions or paying bills on behalf of somebody, please know that at the moment of death, until you are appointed as the executor or executrix of the estate, you do not have the ability to write checks out of the account in the individual's name alone, because at the moment of death, that power of attorney ceases, and your authority as the executor doesn't take effect until after you take the oath and receive short certificates. So meaning after the moment of death until the executor is sworn in as the executor or executrix, there is nobody who has authority. Now, truthfully, that's not a big deal. It really isn't. People understand when somebody dies that they will get paid if they're owed money, but it might take a week or so until the estate is opened. I will say Pennsylvania is one of the easiest states to go through as it relates to probate. There have been states that I have taught in and trained in where people will say to me, look, if you don't avoid probate as an attorney, you are committing malpractice. That is not the case in Pennsylvania. It is really not a horrific process whatsoever. They make it as easy as they possibly can. So that isn't necessarily the driving force for avoiding probate. Probate isn't really all that different than trust administration. In fact, I did written guides for our clients to give them out, and literally I sat side by side the post-death administration guides, the probate and the trust admin, and they were literally identical with the exception of, in probate, the executor has to raise his or her right hand, swear that they will duly administer the estate and abide by provisions of law relating to inheritance tax, and they then sign in order to get the short certificate. So that's really the only difference. Every other step is virtually identical. So as the person who is named as the executor, after the person dies, you will receive death certificates. You will need the death certificate and the original will, and then you will contact the law firm, and the law firm will then be able to prepare the probate petition. They will also then contact the Register of Wills office to schedule a virtual meeting in order to have you get sworn in as the executor of the estate, the personal representative of the estate. Currently, in most counties in Pennsylvania, they are allowing you to do it virtually. In a lot of counties, they do expect that an attorney will be present on the virtual, which certainly we know the counties that do, and we will make sure that an attorney is on there. If not, a paralegal will be on the virtual swearing in as well. So we'll get that set up. Then you will actually get sworn in. If it is virtual, they will have you tip your camera down in order to be able to see you sign, then tip it back up to see you. Then they will issue the short certificates. Once you receive that, that is your ticket to be able to transact business on behalf of the estate. Now, it is your job as the executor of the estate to marshal the assets, to pay any debts, to make sure the inheritance taxes get paid, make sure that everything is done correctly. As the executor, you are personally liable if you don't follow the process of the estate correctly, make sure the taxes are paid correctly, whether it be inheritance tax in Pennsylvania, whether it be any sort of fiduciary taxes that are due to the IRS. If you don't give proper notices and a creditor comes forward later and the creditor says, hey, I am owed money from this estate and there's no money left because you distributed all the money out to the beneficiaries and the beneficiaries don't give the money back, there could be personal liability there as well. So in my opinion, it is not worth taking the risks of not knowing how to handle everything and to ensure that everything is done correctly by hiring another law firm. You will then allow them to be liable, allow them to guide and to dictate the process, and to ensure that all of our I's are dotted and our T's are crossed. Then after you take the oath, that is typically when the law firm will begin providing notices to heirs, notices to creditors, and also then seeking date of death values for all of the assets, for all of the accounts, whether it be investments, bank, you name it. We have to get a date of death value to determine what was the date of death value on the date that the decedent passed away, and that is what we're going to be using for inheritance tax purposes. So that is something that sometimes takes a little while. It seems very easy. It seems very straightforward for companies that have local branches, but they have a corporate office somewhere. You almost always have to send the date of death value request to the headquarters or to the national company and cannot receive it locally. Now, certainly locally it will give you a good idea of a ballpark of what things are worth, but as far as what's going on the tax return, you want that to be an accurate number so that you definitely won't have any issues later. The first timeline or first time deadline that you want to kind of pay attention to is 3 months after the date of death. At 3 months after the date of the death, if you make a prepayment in Pennsylvania, you will get a 5% discount on the inheritance taxes owed. Inheritance tax is based on the relationship of the person who is receiving the money from the decedent. So if I am a spouse, it is a 0 rate. If I am a lineal descendant, children, grandchildren, parents, grandparents, it is a 4.5% rate. If I am a sibling, it is a 12% rate. And if I am anyone else in the world, including lovely nieces and nephews, it is a 15% rate. So depending on the relationship, a 5% discount can certainly be something you want to take advantage of. What I always tell people is, yes, it's always something you want to take advantage of, assuming that there is money there to pay it, right? Like if there's nothing there to pay it at that time because you're waiting on a house selling or you're waiting on something, whether you're going to go and take extraordinary measures to make that payment in order to take advantage of the 5% discount, I think varies person to person, and that's something that you'll want to rely on. But assuming there's money there, absolutely take advantage of it, get your 5% discount. Then the decisions will be made as far as, are you selling real estate? What's happening with those assets? What does the will say? Who are the beneficiaries? Are there any extenuating circumstances? And then when all of that is either sold or the decision is to transfer the assets to the beneficiary, such as maybe the deed to the property, then you'll go ahead and start doing that. And once you get to a point where you are ready, you will file the inheritance tax return. It must be filed 9 months after the date of death. You can get an extension up to 15 months, but you will pay interest, and they do want the payment to be made prior to the 9 months, and then you can get an extension on the return. No problem at all. Now, once that return is filed, most people will provide a partial distribution, if there's money and there's assets in the estate, to the beneficiaries. Now, at that point, you're typically asking the beneficiaries to sign a partial distribution, receipt and release, meaning, yes, I know that I got a partial distribution of the estate. I understand that there is more that should be coming later, but I also understand that if for some reason there is more tax owed than what we held and there's not enough money to pay it, I agree as the beneficiary that I will give it back. But as I mentioned, I don't like to count on that as the legal representative of the executor. And, well, I'm technically the legal representative of the estate. But again, my job is to make sure that the executor doesn't get himself or herself in any trouble. So distributing all the money out and not withholding funds in case there's a tax owed would not be a smart decision. It depends. I mean, how long it takes to get the appraisement back from the Department of Revenue varies vastly. I remember a time where it was 10 to 12 months, and then it was 6 months, and then it was 4 months, and then it was 5 months. So at the timing of your listening to this, it's really hard to predict. I really haven't seen the 10 months or the year probably since COVID. So I assume that was just a time period based upon people not being in the offices and those kind of things. It seems to be much quicker now. But we typically don't want to do final distributions until after we're very certain that the taxes are being accepted as filed. Then when that happens, you're going to do your 5.2 notices, and then you're going to distribute the final distributions and make sure that everybody signs a receipt and release, which is basically saying, I've received my portion and that if anything is needed, I will certainly be willing to provide. So it says that the executor did a good job and that we're not going to go after the executor. So it's just a nice, tight process that is the government's rule book that tells us what has to be done and what are the steps that you need to go through. Now, if there was any gain in the account, such as an estate account, that was opened after the person passed and after the executor was appointed, And if it gained interest during that time, there will be a fiduciary return that will be filed the following year for the prior year on any monies that are owed. Again, that will be taken care of by the law firm and will be filed to protect the interest of the executor, as well as to ensure that the beneficiaries are receiving money that is absolutely theirs. All right. As a general statement, the probate process is not difficult in Pennsylvania. It really doesn't hold up anything. You know, one of the things that I hear all the time is, I'm going to add my son as a joint owner because it's not convenient after I die for them to have to open the estate and wait to pay bills. Well, the truth is, you know, especially nowadays, I mean, death certificates are coming in fairly quickly. Scheduling meetings for virtual probates are happening pretty fast. I mean, you could have an estate open within a week after the person passes and then go directly to the bank and open the estate account and drop the money in it and start paying bills. So we're really not talking very long. And even if you are talking a few weeks, the creditors completely understand that they're not going to get paid immediately. And to me, as I have discussed on numerous podcasts, the risks associated with putting assets in your kid's name or adding them as joint owners doesn't outweigh the benefit. The risk associated with it is too high, and it's not really all that convenient, particularly if something happens to the joint owner, such as going into a nursing home, passing away, going through a divorce, having an addiction or a problem, or losing a job, or filing bankruptcy. I really just don't think that the risks associated with that are worth the fact that it really isn't that much more convenient than just opening up the estate. I think that what people typically don't like about probate in Pennsylvania is the legal fees. But outside of the legal fees, there really isn't, you know, it's not a horrific process. It really isn't. It's really not a big deal. And while I certainly am on record saying that there are advantages to doing trusts and to avoiding probate, those advantages are really for the cost on the back end for the legal fees, the ability to do asset protection after death for the beneficiaries, the ability potentially to do asset protection during life. So there's a lot of advantages that we discuss on other podcasts and other shows and other videos. But the truth is, if you're finding yourself where a loved one has passed away or is passing away, and there is a will, it's not a big deal. Like, it really isn't something that you should freak out about or be concerned about. I find our process is one of the easiest in the countries. We also have, at least locally, two really good registrars in the counties that we are practicing mostly in, which is York and Lancaster County. Certainly it's a joy to work with them. So all in all, don't be discouraged. Don't be worried. Because of the fact that a lot of institutions, most of them, will not allow testamentary trusts under will, you're not able to do asset protection anymore under a will, which is really one of the reasons why I like to avoid probate. But if you're in it, not a big deal. I think I also want to address the elephant in the room. I might have touched on it briefly, but I'd like to just address it directly. I think one of the things that concerns me a little bit personally is that a lot of counties and, a lot of counties in Pennsylvania have issued pro se packets about how individuals can do the estate themselves so that they don't have to hire counsel. And certainly there's no requirement that you hire an attorney. You are not required to use the attorney that drafted the will. You can go to any attorney that you feel comfortable with, and certainly by all means, I encourage you to work with somebody that that you're comfortable with. Where mom or dad did the will doesn't necessarily mean that you have to use that law firm if you are not comfortable or if you have a better relationship with somebody else. So that's certainly just something, that is, you get to choose, as the executor. The costs, associated with it are why people want to avoid it, want to avoid hiring someone. But the issue is, because all these counties are putting out sort of pro se packets, the call that I receive all the time is, Jeff, I opened the estate and it was easy. I can't believe that you were going to charge me for that. That was ridiculous how easy it was. And my answer is almost always the same, which is, you are right. Opening the estate is so easy. It's simple. The probate petition is easy. Producing a copy of the original will and the original death certificate and filling it out is easy. And getting the short certificate is easy. There's no question. But the problem is, at that point forward now, you have to know how to do the creditor notices, the heir notices, that you're going to make sure you take advantage of the discount for the prepayment within 3 months. Then it's the inheritance tax return. It's understanding the legalities of the sale of the home, potentially reviewing contracts, negotiations, if there's an auction, terms and conditions. You have the fiduciary return that has to be filed. You have the 5.2 notices that have to be filed. And if you don't pay creditors out in the right priority, then you ultimately, as the executor, are personally liable. And there is a statute that says, what the priority is, what to do if you can't pay all the people in that class, how to prorate it. Knowing all of that is not necessarily easy. And those pro se packets don't provide all of that information that could be needed or how to do it. Now, it might say you have to file an inheritance tax return. It might say that you have to file a fiduciary return, but it doesn't tell you how to do those. And yes, you could read the instructions for the inheritance tax return to the point where you're able to do it yourself. And yes, you could probably do enough research to figure out how to do all the other stuff that I mentioned. But the question you have to ask yourself is doing all of that extra work to save a few dollars worth the risk that I am taking on by doing it? Because now you don't have somebody that if you messed up to say, hey, I need you to make me whole. You messed up, law firm. You need to make me whole. It is okay, I'm the one who did all the work. I'm the one who's personally liable. I did my best. It took me a ton of time. And now I'm being held liable for something that I really had no idea about, but I was just trying to save a few dollars. My dad always says no good deed goes unpunished. And I really think that that's a situation where the only advantage of you as the executor not hiring a law firm is to save a few dollars. But you're saving a few dollars for your family, for your other beneficiaries. But ultimately, you're the only one with liability. You're the only one who could have an issue if there's something wrong. So you're trying to do them a favor, but by you doing them a favor, you could end up having an issue on your end. So in my opinion, it just isn't worth it. I want to talk briefly here about the executor's commission. So you are definitely entitled to an executor's commission. What I warn people of all the time is, after the death of a loved one, please do not tell your family that you are not going to take an executor's commission. Please do not talk about it. Please do not make statements. Please do not make any bold predictions. The truth is, until you do all of the work and you know everything that goes into being the executor and finalizing the estate, don't make a promise like that. I hear it all the time at the end of estates. Well, I can't take an executor's commission. And I say, what do you mean you can't take it? Yes, you can. And here's what you could be taking. No, at the funeral or right after the funeral, I promised my family I wouldn't take it, that I wanted to do it to help my family out. And now because I said that, I can't take a commission. But holy cow, had I known how much work this was and had I known everything that I had to do, there is no way that I would have taken that on. There's no way that I would have agreed without getting paid. So please don't make any statements that you don't know what you're saying yet. Please allow the process to unfold. Please allow yourself some grace and not making definitive statements until you know exactly what's in it. Now, if you choose to not take one at the end, by all means, please don't take it. But don't say at the beginning that you're not going to, not knowing what you're saying that to, and then doing all the work and then begrudging everybody because you didn't get paid anything and you're the only one who did any of the work. So just sit tight and let the process play out. If you do take a commission, you will get a 1099 that you will have to claim it on your tax return. So generally speaking, if you are the sole beneficiary, you're probably not going to take a commission because it would be better to receive that as an inheritance than to add additional income on your tax return. Obviously, there's exceptions. Obviously, there's other things that go into the decision, but that is a general rule. Now, if there's other beneficiaries and you did a lot of work and you feel as though you want to be paid, you should absolutely take an executor's commission. This is another area where you're going to want legal advice on what is a reasonable executor's commission so that you're sure that if you take it, then no creditors can say that you took too much, no other beneficiaries can say you took too much, the Department of Revenue can't say you took too much. So again, another reason why you want someone guiding you and taking some of that risk and liability off of you. I think what I want to kind of end with is, look, if you're going through the probate process because somebody is ill and you're going to need to do that, it's not a big deal, honestly. Please don't take what I say in the other podcasts about the reasons that I want to avoid probate and that I want to get out of a will and we want to get in a trust as, man, my loved one screwed up because they didn't. The truth is, for some people, that isn't important. Maybe they aren't interested in asset protection during life or asset protection after death for the beneficiaries. Maybe they don't care if the beneficiaries pay a little more to the legal fees on the back end. So there's so much that goes into the decision that I wanted to do this podcast to say, look, if you're having to go through it, that's okay. That is absolutely okay. The other bit of advice that I want to give is if you are the executor, I believe personally that open communication with beneficiaries, reasonable expectations with the beneficiaries are important. Because if you listen to what I said earlier on the timing of everything, it is very possible that final distributions won't be paid out until about a year and a half after the decedent dies. That is to protect the executor from liability. Now, there can be partial distributions prior to that. I'm not suggesting that there wouldn't be money that could get to the beneficiaries, but we want to make sure that we're doing it correctly. And therefore, if you're not communicating with the beneficiaries and they think that 30 days after the decedent dies, they're going to be receiving a check, they are going to think you're up to something. They are going to think that you and the lawyer are running off to Tahiti together. So I believe it's good to have open communication. At our office, we always provide the executor with a post-death administration video as well as a probate guide that talks about all the deadlines, talks about everything. Whether they hire us or not, I want to educate and provide the information. Not a bad idea to maybe give some of that to the beneficiaries so that they also hear why I'm recommending not to do final distribution so it doesn't appear as though you are hiding something or you are trying to steal their money. Wow, this was a fun one for me. I've been doing so many podcasts about why to avoid probate that I think it feels really good to do one on what to expect in probate, what it looks like, what does the timing feel like, what can I expect. So hopefully you enjoyed this podcast of the Red Wagon Estate Planning and Elder Law Show. I hope you learned something. I hope you had some fun. And I hope the time flew by for you. So thank you for joining me. To my listeners, I really appreciate you being here with me as always. And until next time, we'll see you real soon.